And we are live. Hello, Claudia.
Hi, Dorothee.
So I see there are still people joining, so let's just give them a couple of seconds.
Absolutely.
But I think we're ready to go. So, hello everyone. On behalf of the Swiss Arbitration Association, ASA, and the Swiss Chambers Arbitration Institution, SCAI, we welcome you to today's webinar, Force Majeure in Supply Chains. The COVID-19 pandemic has disrupted global supply chains around the world, created delays and disruption, and caused companies worldwide to consider invoking force majeure. You may be affected as customers or as suppliers. We are sure that over the last 2 months, you've heard and read a lot about the requirements of force majeure under different applicable laws. And in today's webinar, we're not going to repeat all of this, but we will take a different angle. We will look at a case study that illustrates the procedural tools that you can use to obtain effective relief in situations where force majeure affects a supply chain. Today's webinar will be given by my colleague Claudia, Götz, Staehelin, and myself. Claudia, would you like to introduce yourself?
Thanks very much, Dorothee. My name is Claudia Götz. I'm a dispute resolution partner at Kellerhals, Carrard in Switzerland. I have a special affinity for life sciences, medtech, and technology disputes. I look very much forward to our today's webinar.
Thank you. My name is Dorothee Schramm, and I'm a partner in the international arbitration team of Sidley, Austin, and Geneva. I see myself as a contract troubleshooter because I help companies resolve their contract disputes either by advising them and representing them in international arbitrations or by deciding on those disputes as an arbitrator. Like Claudia, I have a special passion for life sciences, for technology, and for engineering. And so I'm very excited to discover this webinar platform with you today.
So I am.
So let's get started.
Thanks very much, Dorothee. So for today's webinar, Dorothee and I will cover the following agenda. First, Dorothee will present to you our case study, which illustrates some of the issues that typically arise in global supply chains around the globe every day. Afterwards, I will address the question of how companies can obtain effective and swift interim relief in such situations. Dorothee will then turn to the question of how parallel proceedings can be avoided in typical supply chain situations. We will close our presentations with some practical tips based on what we will discuss today. Lastly, after our presentation, there will be some time for Q&A, so please send us your questions. We hope that you will see a chat room somewhere on your screen, so please feel free to write your questions directly into that box.
Yeah, I see that some of our participants have already discovered the chat box, so welcome.
Good.
Okay, so let me tell you the story of A, B, and C, who have kindly agreed to be our protagonists for today's webinar. Customer A and its supplier B are parties to an international supply contract. Under this contract, B is supplying filter layers for the production of medical masks. B is producing these filter layers using raw materials from its sub-supplier C. Both the supply contract between A and B and the sub-supply contract between B and C contain arbitration clauses, and both clauses call for Swiss rules arbitration in Geneva. So far, so good. But now COVID-19 comes along and things start going wrong. COVID-19 has caught C unaware. How exactly C is affected, only C knows. But be that as it may, last week, C declared force majeure to B and stopped supplying raw materials to B. As a result, B does not have the necessary raw materials anymore to produce filter layers. It therefore has declared force majeure to its customer A and stopped supplying A. so the supply chain has broken down. 1 week has passed since those events, but only yesterday, A learned that B still has some stocks of filter layers, but that it allocates all of them to its most profitable contract with lucky customer D. Needless to say, A is outraged. Claudia, how can A force B to allocate part of its stocks to A?
Thanks very much, Dorothee. So let's look at the business situation of A. As we have just heard from Dorothee, B threatens to deliver the filter layer still in stock to D. A's filter layer business is obviously threatened with considerable and possibly irreparable harm. A therefore has a strong interest in obtaining swift interim measures, obliging B to deliver part of its stock to A. In this situation, A mainly has two options. As we have heard from Dorothee, the international supply contract provides for SCAI arbitration in Geneva. The Swiss rules of international arbitration allow parties to obtain interim measures even before the arbitral proceedings have been initiated. A, therefore, as a first option, could file an application to an emergency arbitrator. This is an attractive option for A. In principle, A could also file a request for interim measures with a competent court. Now, which option is more attractive to A will depend on a number of factors. For example, whether the competent court will be more or less reluctant to grant A's interim relief. For example, because the requested measure is a measure for temporary performance to provisionally enforce the claim. In other words, not a very typical request for an interim measures. Note that in general, arbitral tribunals have wider discretion as regards the content of interim measures. Another aspect may be whether there is a risk that the competent national court could possibly favor the home party B. Equally important may be whether A has an interest in keeping the proceedings confidential. So as A's legal advisor, it seems to me at least that two questions are particularly relevant. How long will it take A to get an order from an emergency arbitrator, and how effective will an emergency arbitrator's order likely be? First, an emergency arbitrator will usually render its decision within 15 days. Swiss rules, emergency arbitrators are appointed usually within 1 or 2 days. So it can be said that the Swiss rules emergency proceedings are fast. Second, in respect to effectiveness, practice shows that interim measures are often spontaneously complied with, without the need to resort to coercive measures. The reason for this is that the party against which the measure is directed does not want to prejudice its position in the arbitration that follows. So assuming A is successful with its request, there seems to be a decent chance that B will comply with the order. So the SCAI court will appoint a sole arbitrator, a sole emergency arbitrator, unless there is manifestly no agreement to arbitrate, or if it appears more appropriate to proceed with the constitution of the arbitral tribunal. And for our case study, let's assume that the court has transferred the case to the sole arbitrator. So let's then turn to the criteria that the SCAI emergency arbitrator would apply when assessing A's request for specific performance. The criteria that have consistently been applied in SCAI emergency arbitration cases stem from international arbitration practice. They are the following. First of all, the emergency arbitrator will assess whether a valid arbitration agreement exists. In other words, whether he or she has a prima facie jurisdiction. Therefore, pathological arbitration clauses are unhelpful and parties are well advised to carefully draft their arbitration agreements. Second, A must show that the harm it suffers is substantial and irreparable. Note that it is not required that A's harm is not reparable by way of damages, however. Third, A must show that it will likely prevail with its claim against B on the merits. Fourth, A will have to show that the relief sought on the merits cannot be awaited. This means that A's interest in obtaining the requested interim measures must outweigh B's interest in having the request decided by an ordinary arbitral tribunal. Fifth, lastly and importantly, A would have to show that there is a risk of serious and irreparable harm that outweighs any risk of harm to B. Best practice here would be to apply a balance of interest test to assess whether the harm of A is so serious to warrant the order for interim relief. Now, as to the measures that the emergency arbitrator may order. In principle, the emergency arbitrator may order all measures that an arbitral tribunal may order. So there are no closed categories of measures. Typically, measures, as you know, include negative injunctions to prevent harm or measures to preserve the status quo. Importantly, as in our case example, an order for temporary performance to enforce a claim is possible as well. Now let's turn to the question how successful A will likely be with its order against B. What are the main two issues in this case? The two main issues are whether A has a prima facie case on the merits, and two, whether A's interest outweigh B's interest. First, as to A's prima facie case on the merits. The relevant and at the same time tricky question here is one of allocating the reduced production output between two customers in a force majeure situation. Obviously, the applicable law will be decisive and the situation will turn on its own facts. As many of you know, I'm sure, contracts often do not provide for a clear solution in such situation, and at the same time the law is unsettled in this regard. Some legal systems solve the problem by allocating the reduced production output pro rata, applying the principle of good faith. According to other systems, the allocation must be fair and reasonable. Depending on the applicable law, it would seem that A has a decent chance to show that it will prevail on the merits if it can show that B is delivering the goods to its most profitable customer and declaring force majeure to A, rather than, for example, allocating the remaining stock proportionately. It would seem that B's course of action is neither reasonable nor fair. In addition, A may have a good chance to argue that indeed B's course of action shows that B is only pretending force majeure, while in reality B could deliver the full quantity. Second, the next and equally tricky question is whether the emergency arbitrator would at all grant A's application for specific performance. The fear may be to prejudice the case by temporarily enforcing a claim that a party shall comply with a disputed supply obligation. It has been suggested sometimes that arbitrators confronted with requests for specific performance should exercise particular constraints. It seems to me that the more modern, appropriate, and at the same time business-oriented approach would be that the emergency arbitrator will have to consider all factual circumstances and weigh A's risk of harm against B's harm potentially in a balance of interest test. If A could not only show that B is favoring its most profitable customer, but that its interest clearly outweigh B's interest, I believe again that A has at least a decent chance to prevail. This might be the case, for example, if A can show that B has only contracted D after the COVID-19 restrictions came into place. A's case may be a bit more difficult if B could show preponderant interest, for example, because D was a critical supplier to an important hospital that treats COVID-19 patients. Of course, again, all factual circumstances need to be considered. Now let's close this scenario with some practical tips for A and for B. So A is certainly good advised to identify and document all the alleged cause of action, the alleged cause of the supply problem. The ability to prove these facts will likely have an impact on the question of how successful A will be in the dispute against B. In particular, A's ability to prove its likely success on the merits will depend mainly whether such evidence is available. A should also ask for more details when receiving B's force majeure notice. A should not accept any unspecific force majeure notice, but rather ask for more details before responding to B. Importantly, A should ask specifically how B is allocating the remaining output of the stock. Conversely, looking at B's position, B is well advised to find objective criteria how B is allocating the remaining output of the stock. As we have heard, pure profitability is likely not a good reason for allocation. So now let's look again at our case study a bit closer. And let's assume that A files a notice of arbitration against B within the required time frame, seeking damages and an order that B continues supplies. A argues that C's failure to supply B does not constitute force majeure. B obviously wants to hold C liable for any damages it may have to pay to A. After assessing C's force majeure notice and its circumstances in more details, B withholds payments for previous supplies as security in case the force majeure notice is not valid. C, obviously, as it must come, threatens with arbitration. Now, Dorothee, how can our supplier B prevent parallel arbitrations?
Now, Claudia, you're right that B has a strong interest in avoiding parallel proceedings for a couple of reasons. First, B may need to take conflicting positions on force majeure in each of the two arbitrations, and that's obviously not very attractive. Also, C, the sub-supplier, holds important evidence of the force majeure, but the arbitration that was initiated by A may go faster, which may prevent B from presenting all of the evidence that it needs to prove its case against A. There's also a risk of conflicting decisions on force majeure between the two tribunals. And finally, if you have parallel proceedings, that duplicates costs for submissions, for hearings, for tribunals, etc. So what are the options that B has to avoid parallel proceedings? There are in theory 3 options. The first would be to file an arbitration against C and request consolidation of the 2 arbitrations. The second would be to wait for C's notice of arbitration, then file a counterclaim, and then request consolidation. And the third would be to request that C participate in B's arbitration with A. Now, if we're looking at A and C, they're likely prefer to separate proceedings for a number of reasons. For example, A and C want to nominate an arbitrator of their choice. So that will be an important aspect for them. And also there's the issue of confidentiality. Most likely A and C will not want to share commercially sensitive information with third parties, for example, information on damages. Now let's look at the 3 options of B in more detail and see whether B has a realistic chance of avoiding parallel proceedings in our case. Now let's look at the first option, where B requests a merger of 2 independent arbitrations, one with the customer A and one with the sub-supplier C. This is called consolidation and is subject to Article 4, Paragraph 1 of the Swiss rules, which is rather liberal compared to many other rules. Under the Swiss rules, consolidation is possible even if the parties to the two arbitrations are different. And the parties' consent is not always required because they have kind of consented to the possibility of consolidation already by choosing the Swiss rules. By contrast, for example, the LCAA rules or the ICC rules would require agreement of all parties in our case scenario. Now, the request for consolidation would be decided by the SCAI court. And the SCAI court is doing a great job in deciding to consolidate proceedings in appropriate cases, but only in appropriate cases. In scenarios where not all the parties agree, the SCAI court is rightly taking a cautious approach. Now let's look at the requirements that B has to meet. You need obviously two arbitrations pending, one between A and B and one between B and C. So that's not a problem. Then the SCAI court will consult with all parties and the arbitrators that are already confirmed and will consider their views as well as all relevant circumstances. And here is where it's getting interesting. Now let's start with the knockout criteria. B first needs to look at the two arbitration clauses with its subsupplier and its customer. If the seats of arbitration are not within the same country, then consolidation is pretty much off the table, unless there is consent, of course. Now, in our case, the seats are identical. It's in both cases Geneva. More generally, the more compatible the two arbitration clauses are in terms of seat, language, and procedural features, the better the chances of consolidation. Now, second, B needs to look at the timing. Consolidation is very difficult if A and B have already chosen the arbitral tribunal in the first case, and if C does not agree to this tribunal. In such a case, the SCAI court can either uphold or replace the tribunal, but this would pose risk to the enforcement of the award, and depending on the country. So in case of doubt, the SCAI court would therefore decide rather against consolidation. So that means that B better be quick to initiate an arbitration against C and request consolidation of the proceedings. Now, if these two potential knockout criteria do not apply, of course, there must be some factual, legal, or logical link between the two cases that you want to merge. Now, the supplier B would argue here that the key question in both cases is whether the sub-supplier C was in a force majeure situation. As B is sandwiched in the middle of that supply chain, it is important for B to have access to the evidence of C and to avoid conflicting decisions. Depending on the specific circumstances of the case, I think these are valid points that speak in favor of consolidation. Now, the SCAI court would also look at whether consolidation would cause delay to the first case. That is an important aspect. And here again, the more B hurries to get an arbitration with C underway, the better the chances of consolidation. Now, finally, the SCAI court would also consider legitimate confidentiality interests of the parties to the extent that those could not appropriately be addressed through procedural tools. So from my view, for example, you could keep submissions and hearing testimony on damages and quantum confidential between the contract partners. So there are ways to deal with these issues. So if the supplier B wants to maximize its chances of consolidation, my tips would be the following. First, check whether the upstream and the downstream arbitration clauses are compatible. And B, initiate the arbitration against the sub-supplier before the tribunal is constituted in the first case and request consolidation immediately. Now let's look now at the second option, where B requests that the sub-supplier C participate in B's arbitration with the customer A. This is called Joinder and is governed by Article 4, Paragraph 2 of the Swiss rules. Under that provision, the party's consent is not always required, and this is again more liberal than under many other arbitration rules. A nice feature of the Swiss rules is that different types of joinder are possible. For example, in our case, B could do one of two things. B could say it could request to join C as a formal party and request an award that C is liable for any damages that B is ordered to pay to customer A. Alternatively, the supplier B could also go for a joinder light and issue a third-party notice with the invitation that C support B in the arbitration with A. In order to decide whether this makes any sense, B would have to look at the applicable substantive law. Under some laws, a third-party notice has the effect that any negative outcome in the arbitration between A and B would also bind C in future recovery proceedings. Now, if it was Swiss contract law that would apply, such a rule does exist, but it only exists for cases that are not relevant here. So under Swiss contract law, this joinder light would not make a lot of sense. But any other law might see that differently. Now, importantly, it is the arbitral tribunal that decides on joinder under the Swiss rules. And that means that B would have to wait until the tribunal is constituted, which means that any objection by the sub-supplier against that tribunal will be very problematic. Now, when we look at the requirements, it's important to understand that joinder is not a daily occurrence, and a lot of this is still unsettled law in arbitration practice. So it's clear you need a request by the supplier B. Now, the Swiss rules would also allow sub-supplier C to request a joinder, but that's not a likely scenario here in our case. Now, in most cases, tribunals require either consent by C or an essentially identical arbitration agreement between B and C. In practice, that's quite similar to the requirements of consolidation. Now, here again, if the sub-supplier C does not consent because it objects to the arbitral tribunal, both consolidation and joinder are very difficult, especially if C is faced with arbitrators that were chosen by A and B. Now, what if customer A does not consent to joining the sub-supplier? Now, this too is an area of unsettled law. Even if a tribunal may not necessarily require A's consent, it is still likely to carefully consider any legitimate interests of A and whether the participation of C would have been foreseeable. Now, B will certainly argue that the participation of a sub-supplier is foreseeable in cases of supply chain disruptions, given how intertwined the different parts of the chain and their liabilities are. I think there is a lot to this argument, but of course it will depend on the specific facts of the case. Now, finally, the tribunal will consider all relevant circumstances. And they're quite similar to those that I've already discussed earlier for consolidation, so let me jump straight to the conclusion. If you are in the middle of a supply chain and want to avoid conflicting decisions, you need to fulfill the requirements of either consolidation or joinder. These requirements are pretty similar, but there are more uncertainties around joinder. Under the Swiss rules, a joinder also comes into play later, and I would therefore recommend that the supplier B focus on consolidation, and if this does not work, give some thought as to whether a joinder light might be a valid option. All right, that leads us to our last slide, Claudia.
Super. Yes, thanks very much, Dorothee. So let's close our presentation with some practical and so to some extent also obvious tips for dispute resolution clauses. First, as we have seen, the emergency arbitrator will have to assess his or her jurisdiction prima facie. Therefore, pathological arbitration clauses are really unhelpful, and parties have said that are really well advised to carefully draft their arbitration agreements.
Okay, and if you are in the middle of the supply chain, you should ensure that the arbitration clauses in your upstream and downstream contracts are consistent. You should also choose arbitration rules with a liberal approach to consolidation and joinder, such as, for example, the Swiss rules. Now, that is it from us. So now we want to hear from you. Let me just see how I can turn off this presentation, and then you should be able to see us a little bit more clearly. All right, here we are. Okay, so you have two possibilities to, I think there should be, in theory, there should be two possibilities to ask questions. One is to raise your hand, and I could try to make you speak, but I can see that for some strange reason, that doesn't seem to be the case. I will give that a try, but no, this doesn't work. Okay, so unfortunately, you will have to write us your question. So you see the chat box on the right-hand side. You can send us your questions there, and you will also see there a tab called Files, and that will actually allow you to download the PowerPoint presentation that you've just seen. But while you're typing in your questions, Claudia, let me maybe start off and ask you, have you ever encountered a situation where such interim or emergency arbitrator relief was requested in a similar scenario?
Thanks, Dorothee. Yes, actually, I have. It's only a couple of months ago where we advised a client, and we quickly found out that this would really, in this case, be a very good option to file an application to an emergency arbitrator under the Swiss rules. The problem, however, was in this case that, and I've stressed that before, that the arbitration clause was pathological, and so because of that and for some other reason, we in the end decided against it. But yes, so I think this possibility to file an application with an emergency arbitrators pursuant to the Swiss rule is really very attractive.
Okay.
And maybe let me then, while people are trying to send us questions, maybe ask you also, Dorothee, having listened to you, how in your practice, what typical issues have you seen in consolidations and joinder?
Well, I think one thing one can observe is that consolidation and joinder are not used as often as it would be probably practical. Mm-hmm. The reason is that, especially in supply chains, it is very hard to negotiate compatible arbitration clauses upstream and downstream. Mm-hmm. So that is obviously a problem if you have different arbitration clauses calling for different institutions. That will oftentimes make consolidation and joinder impossible. Mm-hmm. Now, I do have some hope here. We see more and more companies actually establishing dispute resolution policies where they're really taking a very strategic approach and agreeing on the same arbitration clauses or a very limited number of options in all of their contracts. And the more this trend will apply, the more we might see more consolidated or more compatible clauses upstream and downstream. Mm-hmm.
It's actually an interesting thought, and in my previous role, I obviously dealt a lot with the question of how such policy should be rolled out, and I think sometimes exactly the reason you just mentioned are not so much in everybody's mind, but I do think that this is a really important aspect.
All right, so let's look at the questions or the comments that have come in here. So thank you for the compliments. We always like compliments, obviously. So there are some helpful comments from Caroline from the SCAI. First, that there is SCAI posted recently some documents on emergency relief. So you should check out the SCAI LinkedIn post to get more information on that. And she also pointed out earlier, I think, that even if you do not have an arbitration clause now, obviously the parties can still agree on arbitration after the dispute has arisen. And if you want to do that, then you might want to can steal maybe a little bit more the compatibility of different arbitration clauses. Now, there's a question about whether we have a model arbitration clause that meets our suggestions. I think I don't know, how do you think about that, Claudia? Our advice is always start copy-pasting the model clauses of the institution that you choose, and then change only what is really necessary and what really makes sense, and keep the changes light.
Absolutely, I couldn't agree more. Yes.
The good thing, I mean, the Swiss rule, I must say, I've built a number of model arbitration clauses for a tool that we develop for companies. Mm-hmm. And I must say that the Swiss rules are amongst those rules where I need to change the least. I have to change a lot more with certain other institutions, but issues like confidentiality or consolidation and joinder is already pretty appropriately addressed in the Swiss rules. So you tend to need less changes there than with many other rules. So that's just a personal observation. Also, if you have a Swiss seat, that requires oftentimes less changes than if you have other seats like the UK or the US, where you have to add a lot more language in order to get to the same result that you get here as a standard.
Mm-hmm. Absolutely. And Caroline is again telling us where we can find SCAI model clauses.
Okay. Now you have, Claudia, there's a question about to support applications for emergency relief. Is there any way to obtain evidence through discovery, or would we practically need to obtain our evidence through other means? Thank you for that, Andrew.
Yes, so I have stressed the aspect that I do think, first of all, it is important to have the evidence ready, and some practical tips are really for A and for B to make sure when we receive in the context of force majeure notices to really react to these notices. I think that is in the case that we have presented really the important aspect. Now, as to discovery, if you're asking whether a full-fledged US discovery is something which would be applicable in an arbitration, it's probably a bit of, the question is no, this is not the way that would work. But obviously, there are ways to getting some evidence from the other side, yes. But I think when you want to apply for emergency relief, you are well advised to have the evidence still with you, because you have to move fast. And I think the point here is really and therefore the tips to make sure that you get your evidence right away, because you're under time pressure.
Andrew, you can, of course, you were probably wondering, how did B actually find out that? How did A find out that B was allocating all of its stock to the lucky customer D? Now, I think, if they heard that from an employee or so, in case of emergency relief, you would probably file a witness statement of whichever person heard that from somebody within the organization of B. And then, the emergency arbitrator would just ask A outright or B outright, and we would see. But, you can file witness statements, but, obviously your means of getting evidence are better in normal proceedings.
Because you need to move quick, right?
Yeah. So here's a question from, or a comment from Bruce Gailey saying on Consolidation, saying, consider that companies might be negotiating arbitration clauses that are not compatible on purpose, specifically to eliminate the possibility of consolidation. I think that's perfectly possible. You might as well just leave them compatible, and if you don't want consolidation, just say so. But obviously, if you don't want to be quite that explicit, obviously, you can exclude consolidation by making them incompatible, either by terms of institution or different seats in different countries. So there are different ways how to avoid that. There was some question. So what do we have here? There is a question. Yes? Go for it.
There's one for you, actually. And the question is, how well are clients aware of the possibility of consolidation or joinder in supply chain arbitrations from your experience?
Whether they are, are clients aware of the possibility in supply chain arbitration disputes? Yes. No, oftentimes not. That's exactly the reason why we chose this topic today, to create more awareness around this. So it is something that does not happen every day, but it is actually really a useful tool that many of you know from state court litigation, but that people somehow don't think about when they're talking about arbitration. And so that was one of the reasons why we chose that topic. We have here another one saying consolidation will be against the interests of A. The contract between A and B is not subservient to supplies only from C. B is obligated to get raw materials from any vendor X, Y, or Z. Now that depends a little bit, obviously, what contract we're talking about. If the raw materials are qualified, have gone through a qualification process for the specific use at A, that A has, then typically B would have to deliver exactly those raw, the filter materials that have exactly those raw materials. Now, when it comes to mass, that's not a very likely scenario. When we're talking about drugs, we might be talking about a very different scenario. But often, obviously, if you don't have, if B could just get the raw materials from X number of different suppliers, then it's going to be a lot more difficult for B to invoke force majeure. So that's, I absolutely agree with your comment there. So I think I don't see any further questions. And I think we are about 4 minutes ahead of time, but I don't think anybody will be very mad if we let you go a few minutes early. And thank you very, very much for joining us today. This was the first webinar that we held here for ASA and SCAI in this format. It was a nice kickoff. You were a great audience, and we thank you.
Thank you very much.
Bye-bye.